I'm going to remind you that you are under oath.
Yes.
Okay. So where we left off, Brian Wittrup, the administrator who could initiate your transfer out of state, a transfer Stephen Gray threatened, was in an email exchange with Trevor Clark, the accused PREA violator, Paul Shoemaker, who engaged in PREA retaliation, and Stephen Gray, who threatened further PREA retaliation, and Brian Wittrup was advocating interstate transfer?
Yes.
What would be the possible rationale for sending you out of state?
Well, there really isn't one, legitimately. You have to figure, in order for an out-of-state transfer to begin, you have to first have an accusation of rule violations. You're issued a conduct report. You go through the disciplinary process. You're found guilty of rule violations. They have a determination as to what to do, which may include raising your security. And if the security is raised, in very rare circumstances, usually involving like violence and rape, they may recommend out-of-state transfer. None of that had happened. So all that had happened here is that Stephen Gray had essentially sent my attorney an accusation of things he called misconduct, which was really kind of a word salad. And he had just riled up all of these people. And if you notice in the email exchange, it began with Trevor Clark with a big blacked out whatever, so we don't see what he says. And the title of all of this is Swain Harassment of Me.
Okay, let's turn the administrative charges that Stephen Gray threatened if you did not drop the PREA claim. According to your disciplinary history on PREA, pages 0076 through 0077, the next disciplinary action taken against you was SOCF 15001327.
Yes.
Go ahead.
The context for this, I was at the Southern Ohio Correctional Facility, 2015. This is May. The Assistant Chief Inspector Paul Shoemaker wrote a conduct report. This is the same guy who suspended my communications before. And in this conduct report, he claimed that I threatened every employee of the ODRC and their families with bodily harm. And so this conduct was sent to the hearing sergeant, who was extremely mad because he has a family. And he was mad until I told him to read the to read the actual article that was affixed to the conduct report. So he read the article. And I said, look, that's a statement opposing the international crime of torture. It's for a symposium on torture. It has nothing to do with the ODRC. I'm not threatening anybody. I'm talking about how to respond to the international crime of torture. And so he said he would do me a solid, and he found me guilty but gave me a verbal reprimand rather than sending me to the disciplinary panel, because he said he was ordered to send me to the disciplinary panel, and they were ordered to recommend me transferred out of state.
Did Paul Shoemaker, who suspended your communications for reporting Trevor Clark's sexual misconduct, again, here suspend your communications?
Yes. PREA page 84 includes an email by Paul Shoemaker suspending my communications. And significantly, he did it 8 days before the hearing officer heard my conduct report.
So Paul Shoemaker wrote the conduct report and then imposed punishment before you ever had a hearing. How did he know you would be found guilty?
If you look at PREA pages 85 through 89, those are email exchanges between Charles Miller, who's the investigator at SOCF, and Paul Shoemaker. And Miller said to Shoemaker, I told them to hear it and send it to the RIB. Any special instructions? And Shoemaker, just tell them it is a very serious matter. And then we have Rob Jeffries on page 85 saying, good candidate for interstate compact. So this discussion, they're actually telling the sergeant, bind it over to the Rules Infraction Board, the RIB, and tell them it's a very serious matter. And then the email exchange includes somebody commenting that it looks like a good candidate for interstate compact, letting the RIB know to recommend me for an interstate compact transfer. So this whole thing was designed to corrupt the process.
So these email exchanges prove what the unit sergeant disclosed to you, that officials had corrupted the disciplinary process in advance to manufacture a justification for sending you out of state, as Stephen Gray had threatened and Brian Wittrup had advocated.
Yes.
And all of this was done by the same group of PREA retaliators recruited by Stephen Gray with his dog whistle letter.
Yes.
The following month, you were interrogated by Edwin Voorhees, the assistant director.
Correct.
In other words, drop the PREA claim.
Well, wait a minute. Okay, so let me back up. Yes, I was interviewed by Edwin Voorhees. He's the second in command of the ODRC. He told me he had never met anyone one-on-one before, a prisoner one-on-one. In the course of that interview, he asked me. This is a month after the interstate transfer plot was foiled by my unit sergeant. In the course of this interview, he asked me to drop the misunderstanding with Trevor Clark.
So, in other words, drop the PREA claim.
Yes.
What did he say he would do to you?
He said he would make my life a living hell.
So the next administrative retaliation was WCI 16-00885.
Yes. So this is late 2015 at Warren Correctional. I was called to the investigator's office. The investigator stood outside the office, and I was alone with Trevor Clark in the office.
Again, is it common for ODRC counsel to go to a prison and meet one-on-one with a prisoner?
No.
Is it permissible for staff accused of a PREA violation to meet one-on-one with a PREA accuser?
No.
Do you know of any prisoner who has had multiple one-on-one discussions with ODRC counsel?
No.
What did Trevor Clark say he wanted?
So, he had drawn up a gang activity conduct report, a Rule 17, for someone else's mail discussing me, and decided he was going to charge me with gang activity based on somebody else's conduct. But he said he would forget about it if we could resolve the misunderstanding. And then I would be able to go to level 2, medium security, at my next security review, get programs, maybe get a parole.
Misunderstanding. Same word Assistant Director Edwin Voorhees used when he threatened to make your life a living hell.
Yes.
How did you respond to Trevor Clark's offer?
I accepted it. I realized these people were just never going to stop with their nonsense. And so I wasn't happy about it. I felt like I was compromising my principles, but I had to get to medium security. I had to get programs, and I had to get a parole. So I was willing to drop the PREA thing, and I told them so.
Did the offer maintain?
No. After the first of the year, about a week or two later, Trevor Clark returned. He revoked the deal and said the conduct report would be issued, and I wouldn't get a parole unless the parole board had a collective aneurysm.
You were found guilty of gang activity as a consequence of Trevor Clark's retaliatory conduct report.
Yes, and the RIB chair, Robert Nelson, said there wasn't anything that he could do because it was involving Trevor Clark in central office. And I know that to be the case because we have the other evidence of them tampering with the Rules Infraction Board going back to the other case. So, yeah.
How did that retaliatory conduct report impact you?
So it impacted my security. I have security reviews. At this time, I had a security review every July. So I had to remain conduct free for an entire year going to the next July, and I could get my security lowered. Well, This impacted my ability to get my security lowered in July of 2016. And I had to see the parole board that spring, and the parole board brought this up, the gang activity. And I ended up getting a 5-year continuance.
It impacted your security and privilege level, just as Stephen Gray had threatened.
Yes.
Is it permissible for a staff member accused of PREA violations to be involved in disciplinary action against their accuser?
No. It's a violation of PREA. And moreover, there are thousands of people who work for the ODRC, but it seems that nobody can charge me with rule violations, and nobody can involve themselves in disciplining me except Trevor Clark and his posse of PREA retaliators.
Did the parole board consider that misconduct contrived by Trevor Clark?
They did, yes.
And what did they do?
They gave me a continuance of 5 years.
The next retaliatory administration action is WCI 16007856.
Yes. So this happened after July. So this would implicate my security review for 2017. On orders of Trevor Clark in September, my cell was searched, and they confiscated my own writings and called it contraband. The PREA pages 90 to 92 show the involvement of Edwin Voorhees, Trevor Clark, Stephen Gray. And then after I was found guilty of this, Lieutenant Robert Nelson, the RIB chair, CC'd Kevin Chamberlain. Kevin Chamberlain is significant because at this point he is their point man for the retaliation campaign. He's the one who actually issues all the conduct reports in his name that they've written for him.
The next retaliatory administrative action was WCI 16-10754.
Yes, so I wrote a grievance. And so based on me having written a grievance, they accused me of extorting a deputy warden. PREA page 95 shows all the administrators emailed the results of that hearing from Lieutenant Nelson, including Kevin Chamberlain, who was Trevor Clark's local proxy.
So all of these irregular administrative actions that Stephen Gray had threatened in his letter, if you didn't drop the PREA claim against Trevor Clark, had negative impact on your security level, just as Stephen Gray threatened.
Yes.
The next retaliatory administrative action was WCI 18-002337.
Yes. So, just some context here. The previous disciplinary actions that they had contrived had already implicated my 2017 security review. And so, after July of 2017, I would have to go an entire year without conduct reports in order to drop in July of 2018. So we get to March of 2018, just a couple of months before my security review, and I had had no disciplinary action. And on orders of Trevor Clark, I was tossed in the hole for an outgoing email that they found unflattering and insulting. In the email, I had called ODRC retaliators. I had called them fascist fart goblins.
Is it customary for prison officials to target prisoner outgoing communication for unflattering commentary?
No, and not to get too deep into the weeds, but the U.S. Supreme Court has a huge succession of cases talking about what constitutes free speech and what does not in terms of prisoners. And they have no, by the Supreme Court's decisions, they have no penological interest in outgoing communication that they find unflattering. And so they never target that. This is the only time I've ever known where they've actually read somebody's outgoing email and got mad and then threw somebody in the hole, and didn't just resolve it with the hearing sergeant, but actually tried to take it to the RIB.
So why would officials irregularly target this communication and attempt to manufacture a rule violation?
Well, I think this is very illuminating. It's the end result that they're looking for. They want me to have the disciplinary findings that stop me from dropping in security. And their biggest frustration is that I never break the rules. So they're looking very, very hard to find a way to keep me elevated. And the worst thing that they can do is fabricate ridiculous nonsense regarding other people's mail or read my outgoing communication that they find unflattering and manufacture rule violations from it.
So in this situation, what happened?
PREA pages 97 and 98 show exchanges with Kevin Chamberlain, Trevor Clark. So I promised to drop the PREA against Clark and issue letters of apology, and I would get my security lowered in June and be able to get programs. And so they accepted that. I got a verbal reprimand from the unit sergeant. PREA pages 102 to 104 show the responses of Clark and Shoemaker when they were informed as to the outcome of the disciplinary matters, which leads to the question, why is an attorney at central office being included in a disciplinary matter about unflattering outgoing communication from a prisoner when you've got 50,000 prisoners? It's clearly irregular that these people are hyper focused on me.
Did you drop the PREA?
No, I lied. Instead, I sued Trevor Clark and Kevin Chamberlain in Franklin and Warren counties. That's PREA pages 8 and 10 are screenshots of those dockets.
Why did you pursue civil litigation against Trevor Clark and Kevin Chamberlain?
Because I realized they'd never stop. They would never keep their word on any agreement anyway. So I needed the court's protection. The Warren County case was filed on the 7th of May, 2018. Clark was served on 23 May. So I sent discovery I sent discovery, and Clark was served that discovery on the 7th of June on a Thursday. That included interrogatories and document requests related to his PREA transgression, and I sent him admissions. And what I was seeking were all of the documents that were concealed for years that are now part of this archive.
Did Trevor Clark answer discovery?
No, he had me tossed in the hole. In SEG, you don't have legal work, so he had Kevin Chamberlain, his co-defendant, toss me in the hole.
So two defendants in civil litigation, one of whom is accused of sexual misconduct and under investigation, colluded to place you in segregation while the lawsuits and investigations were going on.
Yes.
On what disciplinary charges?
I didn't have any. I was simply placed under investigation. So investigation is kind of a catch-all. According to the email archive, Trevor Clark and his friends began looking for a justification for putting me in SEG the day after they put me in SEG. So it's kind of like the cart in front of the horse thing. They tossed me in the hole, then looked for an excuse for me being there.
So Trevor Clark, accused of PREA, and his co-defendant Kevin Chamberlain placed you in segregation and then looked for an excuse to justify segregating you?
Yes.
How did you respond?
I went on a hunger strike. I was distraught. I even wrote my own obituary. I was at the end of my rope.
And that is described in internal emails in PREA pages 0018 and 0019?
Yes. Robert Welch was the deputy warden of special services, and he was in charge of the hunger strike committee. And there was a whole bunch of people on it. Another deputy warden, unit management administrator, my unit manager, the head of the mental health, the head of medical, the major, a shift captain. All these people were on the hunger strike committee in the room with me during the hunger strike committee meetings.
So to address something out of order later on, When they would finally fabricate disciplinary charges, Trevor Clark and Kevin Chamberlain would point to you writing your own obituary as a threat to harm ODRC officials.
Ironically, yes. So being driven to suicide by them constitutes a threat of bodily harm against them.
Okay, but that was later. Returning to the narrative, when did you end the hunger strike?
I ended the hunger strike on Friday, the 22nd of June. I was released from segregation the following morning with no disciplinary charges. I was back in population until the 29th of June and then placed back into segregation. And that's an important fact given the later accusation regarding the Hunger Strike Committee, that I was let out of SEG after the Hunger Strike Committee hearing. I was let out. I was in population for a week and then brought back to segregation.
On what date would Kevin Chamberlain finally issue a conduct report, and what were the accusations contained in it?
Okay, so July 2nd, he finally issued the conduct report. That appears as PREA pages 11 to 15. He accused me of extortion, rioting, and gang activity. The conduct report accused me of writing an article that was found online advocating the use of drones to drop guns into prisons. And it alleged that during my hunger strike committee hearing meeting, I threatened to burn down prison administrators' houses. I didn't write the article, and I didn't threaten to burn down their houses.
Of the two accusations, let's first discuss the article attributed to you. Do you have evidence that Trevor Clark, Kevin Chamberlain, and others falsely attributed that article to you in order to justify retaliatory results?
Yes. So, first, my communications were suspended in April over the Fart Goblin's email. They never restored my communications. And that's something that they knew. I was black-sided in place, so I had no way to communicate an article to the outside world. My counsel, Pam Starcia, had contacted the website and had found that the writer was Jules Demore from Oregon, who issued a sworn statement that the ODRC worked very hard to keep from my disciplinary hearing. They didn't want them to see it. PREA pages 16 and 17, Brian Wittrup and DJ Norris, the investigators, admit there is no evidence, and Wittrup's plan to get me to confess. And that there was nothing presented at the hearing other than the conduct report that simply said, I wrote the article. So that this is something that they just created in order to justify an end result.
By their own emails, the investigators admitted there was no evidence connecting you to the website or to the article.
Right, in their own words.
What about the accusation that you threatened to burn down prison officials' houses during the hunger strike committee hearing? Do you have evidence that Trevor Clark, Kevin Chamberlain, and others falsely attributed those threats to you in order to justify retaliatory results?
Yes, and I'm going to start the answer. We're probably going to have to continue it when we start back up again. But I was in the hunger strike committee hearing with a whole slew of people that I've already described. And you would think that they would say something if I had threatened to